Good morning, everyone. Sorry for this technical glitch. I, Assistant Professor Neelam Dighe, welcome you all to this workshop organized in collaboration with Indian Patent and Trademark Office, Mumbai. Now, without further delay, I would like to invite our beloved Principal Ma'am to grace this occasion with her valuable insights.
Thank you so
Yes,
much, Neelam Dighe Madam. I, Dr. Sunita Ada, Principal of PE Society's Modern Law College, welcome all of you for this workshop on awareness in intellectual property
morning, everyone. Sorry for this
for
technical
the
glitch.
aspiring
I,
minds.
Assistant Professor
And
Neelam Dighe, welcome you all to this workshop organized.
yeah, shall I continue? I welcome all of you
Yes,
for
ma'am.
this
Yes.
workshop on awareness in intellectual property rights for the aspiring minds. This particular workshop is in collaboration with Indian Patent and Trademark Office, Mumbai, which is under the Azadi Ka Amrut Mahotsav, which started 75th anniversary of the Indians' independence. Just to tell you briefly about Progressive Education Society and about the Modern Law College, a brief introduction, I would like to tell here that Progressive Education Society was established in the year 1934. It was on the auspicious day of Akshaya Tritiya, which was on 16th of May 1934. This particular society was started under the able guidance of late Sri Guruvarya Shankar Rao Kanetkar Guruji. Progressive Education Society, it is one of the premier legal institute in Maharashtra, which is situated very close to Savitribai Phule Pune University. This particular educational institution is providing education to more than 53,000 students. It also has today more than 3,500 staff, which includes teaching and non-teaching staff working under the umbrella of Progressive Education Society. We have today in all 62 units which are working very efficiently under the able guidance of Professor Dr. Gajaran Igbote sir, who is the chairman of Business Council of PE Society. This also provides education right from KG to PG and also the research centers. About Modern Law College, Modern Law College is functioning under the umbrella of Progressive Education Society. Our college is permanently affiliated to Savitribai Phule Pune University. It is recognized by Bar Council of India and it is also recognized under Section 2F and 12B of UGC Act of 1956. We are accredited in the year 2017 by Bangalore, NAC Bangalore with CGPA of 2.84 with B++ grade. This college stands one of the best law colleges in Pune. All the courses of our college, be it a PG or be it a UG, all the courses are affiliated to Savitribai Phule Pune University. We are approved by the university, and I feel very glad to tell you that this year we have got a permission for the another course, that is BBA LLB and also PhD Research Center in Law under the humanities categories. The academic excellence of our college is manifested from the results of the students of this college, which is not only in academics, but also in sports, curricular, and extracurricular activities. Students have really won laurels for the college in all state level, national level competition, be it education, debate, or moot court competition as such. Today, we have more than 1,400 students which are taking education in this modern law college. Every year, college organizes various activities, and many of these activities are in association with the State University of Savitribai Phule Pune University, like national level, state level seminars. Also, we have national level moot court competition, Shankar Rao Kanetkar moot court competition, which is at a state level, but we are planning to have this at an international level also, along with a national level. We also have other activities like Duff Karanda, which is a street play competition, again, which is in association with both students' development. We are also implementing various earn and learn schemes and various other activities. This Azadi Ka Amrut Mahotsav has started, that is its 75th anniversary of India's independence. This Mahotsav has launched 75 weeks before. It was on 15th of August 2020 and it will continue up to 15th of August 2023. Today, we are living in the midst of information revolution. The IP system, it is an artificial concept that exclusively rewards the owner of intellectual property, granting them monopolies over the invention and also ideas, which in many cases are the product of generation of thinkers or publicly funded research. Intellectual property is a result of conversion of knowledge into a commercially exploitable potentials. It is for the betterment of all the nations that we promote intellectual property rights. Only the societies where the rights are protected, it witnesses a cultural advancement and also the economic progress. We need to bring down the concept of intellectual property rights from the ivory towers to the legalistic jargon of a common man. Intellectual property is spawned in all branches of human life. The future clearly belongs to the innovative societies, and I'm sure that these discussions and exchange of ideas and views will really give a boost to the awareness in regards to intellectual property rights in developing countries. With this word, I have a great pleasure in inaugurating this workshop on awareness of intellectual property rights for the aspiring minds. And I, in person and also on behalf of Modern Law College, welcome all of you for this workshop of one day. Thank you so much. Over to you, Dighe Madam. You can please continue.
Yes, thank you so much, Mrs. Sunita Adhao, ma'am. Thank you for your valuable time. Now I would call upon Assistant Professor Prajakta Bhagwat to further introduce our chief guest, Dr. Ajay Thakur. Over to you, Prajakta ma'am. Good morning, all of you. Good morning, sir. So your mic is mute.
Good morning, madam.
Good morning, sir. Sir, now I would like to introduce you. Okay. So, guys, the first resource person, that is Dr. Ajay Thakur. Dr. Ajay Sadashiv Thakur holds the following education degrees in his credit. He has done MSc in Biochemistry, MMS, Masters of Management and Science, then MPhil in Marketing Management. He has hold the PhD in Marketing Management. He has also done LLB, LLM, IPR, and IPR various certificate courses from World Intellectual Property Organization. He has also worked as a senior scientist officer in Hindustan Antibiotic Limited, worked on deputation with RPG's Life Sciences. Presently, he is working as an assistant controller of patent and design in Patent Office, Government of India, Ministry of Commerce and Industry, Mumbai. Dr. Ajay Thakur also has attended training in USA and Japan. Last but not the least, he has also done research project on production of banana cream from the banana waste by fermentation in Agarkar Research Institute. He has conducted over 1,000 patent awareness programs in various industries, universities, and colleges. I find myself honored to get a chance to introduce such an eminent person. It's our proud privilege to have you today, sir. Over to you, sir.
Good morning. Hope I am audible as well as visible.
Yes, sir. You're audible and visible too.
Okay. So, respected Honorable Gajanan Ekbute, sir, Honorable Chairman, Progressive Education Society, and then Dr. Sunita Adhao, Honorable Principal of Modern Law College, Dr. Neelam Dighe and Dr. Prajakta. I'm very much thankful for inviting me on this occasion of Azadi Ka Amrut Mahotsav. So we being the part of Patent Office under the National Intellectual Property Awareness Mission, we are on a mission to train 10 lakh students with regards to IPR and its domains. So different types of intellectual properties, how these properties are governed, and we are making aware of all these things, how to file patents, how to file trademarks, copyrights, and all. We will discuss in detail all these things in my session, along with one of my colleague, Mr. Amol, who will join later, right? So let us not waste much time on that thing. I would like to share my presentation and like to aware. Madam, one request, kindly allow me to share my screen sharing.
Yes, sir. I have made you the host.
Okay. Okay. So we will start with what is intellectual property. Madam has rightly pointed out that intellectual property is the conversion of knowledge into some important things that are useful for not only for the society but also for the nation. Now we will start with my presentation. Hope it is visible to all.
Yes, sir. Yes, sir.
Is it visible, sir?
Yes, sir. Yes.
Okay. Just a minute. Okay. So presently we have gathered here for the one-day workshop on the National Intellectual Property Awareness Program under the National Intellectual Property Awareness Mission, NIPAM. So I'm hearing some voices. Can you please mute your mics, all the other participants? Okay. Coming to every day we are hearing the word IPR, intellectual property, patents, designs, trademarks. Many times you hear people are saying some different kinds of words. Iska to patented word hai. Just a minute. Amol 11 वाजता join कर. काय problem? Amol? हाँ 11 वाजता join कर. 11 वाजता बरोबर ठीक आहे. हाँ काय problem नाही. मी करून देतो. Okay. Madam, there is a child, some person has kept his speaker on and ask them to please mute them. Hello.
Hello. Am I audible?
Yeah, audible. Madam, somebody is some child is speaking.
Mr. Siddheshwar Gore, can you please mute yourself?
Okay. Now we are coming across this kind of word every time now, but people are saying there are different myths about intellectual property. So what is intellectual property? That we will see. First of all, intellectual property is like another property, but it is in sort of intangible. It cannot be seen by naked eye, but it is present there. Now what is that? We will see. So basically IPR is the collective term for intellectual property rights. That means rights. So whenever you own some property, you have right to that property. Now what that kind of properties are, we will see. So intellectual property broadly means the legal rights which result from the human intellectual activity in the field of industrial, scientific, literary and artistic fields. Now what are these fields? That we will see one by one. So first of all, when we talk of industrial property, that includes patents for inventions, trademarks, industrial designs, as well as geographical indications. Whereas we also have another domain under which intellectual properties are registered, which covers the copyright. So these are the basically main ingredients of this today's session. Now, what is intellectual property? Now, intellectual property is the property which is the result of human intellect. So greatest gift given by mankind to mankind by God is his human brain, and this brain has the ability to think, to act, and to think of such ideas, and which these ideas, when converted into some form of tangible things or some part of instrument, some parts of instrument or some other research things, which is definitely beneficial to society. So that part is nothing but the intellectual property. Now, when we see talk of properties, immovable properties are there, that is land, houses, and building. These are the properties which can be seen by naked eyes, and one cannot be these properties cannot be moved from one place to other. Whereas we also have movable properties, that is car, pen, dress, furniture, etc. All these things are also the properties which can be moved from one location to other location. So these also can be seen. But when we talk of intellectual property, we have to know that intellectual property is nothing but is an intangible property. What is that intangible property? Means you cannot see this property by eye, but it is present in the articles of trade. How? So I will explain it. So see, we are using a mobile phone daily, every day, right? We have certain buttons which we press. Once you press that button, your Facebook gets activated. Once you press another button, your WhatsApp gets activated. If you press that some button, then you get some contact lists. You can sell email or you contact persons. So different value-added services can be used. You can use radio. You can use different sort of things which can be done through your mobile phone. But you know only to press that button, and because of which that mobile functions. But nobody is aware how that mobile works, how that, but once you press that button, what happens to that mobile, and because of which that result is how that WhatsApp gets activated. Nobody is aware of. So basically, this is the intangible property that is present in the mobile phone. Something is there, because of which this mobile phone is working, and that in something which cannot be seen by naked eye, but it is present in the mobile phone, and because of which that is working. So that something is nothing but the intellectual property. It's a human intervention, that because of which some activity is carried out or some research work is carried out, and because of this the mobile phone functions in that way. Similarly, when you press a remote of your TV, the channel gets shifted. So something is there. So that something is nothing but the intellectual property. That is what I wanted to convey. So it is cannot be seen, but it is there in the. So basically, it is also one of the property, and therefore you have right to that property. So you cannot use, just like once you purchase a car, nobody can use this car without your permission. Similarly, when you get some intellectual property right, this property right cannot be used by another person unless and until you give permission to use them, right? So when you talk of intellectual property, we have different domains: patents, designs, trademarks, geographical indications, copyright, semiconductor integrated circuits, layouts, and plant varieties, and as well as trade secrets. Now, we have many misconceptions. I know there are people who come to patent office and say, sir, I have written a book, or I have written one poem. Can I get a patent on that? Similarly, many people come to us, sir, I had made something, I want a copyright on that. So these different myths or different this kind of thinkings. Then that time we have to say that, sir, you have written a book, so we cannot give a patent to a book. Patents are granted to inventions, and books are being necessarily covered under the copyrights. So you have to necessarily file a copyright and not a patent. So this what kind of intellectual properties are there? So first of all, understand intellectual property is nothing but a result of human intervention, human intellect, human brain thinks of something and which acts in that manner, and that because of which something useful is made to the society, and that definitely contributes to the nation's progress. So there is a need that intellectual property need to be protected, and therefore intellectual property rights are enforced. We have a very proper intellectual property rights regime under which different domains of patents, designs, all these things are registered. Now we will see what are the aspects and how these intellectual property rights are registered. First of all, what is the need of intellectual property? First of all, the question comes, kya karna hai? See, you have an idea, you prepare something, but at the same time, if you don't have any protection, somebody will easily copy it. There are chances that this might be easily copied by some persons, that may be stolen by some person, and immediately he will start producing it. Therefore, the need arises to control or to protect the intellectual properties. Now, why there is a need? We see the technologies are changing rapidly. Earlier there was 2G, 3G, 4G, now 5G is coming. Even further researches are going on. So technologies are changing rapidly. Similarly, in every sector of development, technologies are changing. You had a big box like TV, then we had a plasma, then we had a LCD, then LED, all these, and now OLED. All these are nothing but the technologies development. Similarly, the investment. Now, when we talk of in technologies, we need some investment, and investment in research and development is also very high. And therefore, the production, then marketing also have become very high. Apart from that, the product life of that period is also very short. That product which we are preparing is very short. One can easily say that the newspaper of today is a waste of tomorrow. Similarly, things are happening in these technological fields. Every day you are coming across new technologies and new developments in the different products. Therefore, the product life of that product is becoming shorter, and industries also have become very competitive. Once Samsung launches another thing, Realme launches another thing, Oppo launches other things. All these things are nothing but the competitive environment which is being created around this phone. 50,000 phone from Samsung, which is costing, you are getting similar features in 40,000 with Realme or in any other company in competition. That may be Oppo, Vivo, or any other companies. So this is nothing but the need. So therefore, when we are talking of technologies, when we are thinking in terms of research and development, other production costs as well as overhead cost charges, that may be marketing expenses, then again considering the product life of the cycle, product life cycle of a product, also the environment is competitive. So when these kind of things, therefore we need a strong intellectual property that has to be there in place. Now, when we talk of intellectual property rights, I told you it is a result of human interaction. Now, what is that? Apart from that brain, we need some resources. That resources may be in the form of manpower, labor, research, money, laboratory, experiments, many type of raw materials that are resources which are required to conduct. So it is not easy. Therefore, it is very essential that this intellectual efforts which are created by these individual persons need to be protected, and therefore a strong intellectual property rights regime is required, and therefore we also have in place in India a very strong intellectual property rights regime. Now what is the purpose of giving intellectual property? I told you there are chances of this raw intellectual properties may be getting stolen. So gives, and somebody can easily copy it. So to give statutory expression to the moral and economic rights of the creators in their creations, and the rights of public in access to those creations. So once you create something, it is very essential that you need to have some protection, and nobody can use that creation without your permission. So this is nothing but to promote as an act of government policy to encourage creativity and dissemination and application of his result to encourage fair trading, which would definitely contribute to the social and economic development of the country. So basically, to give moral recognition to rights and to encourage the inventors or the creators of the intellectual property, the main thing is these are the objectives under which these IPR policies work. Now, I told you about intellectual property, different types of intellectual property, and apart from their uses, why intellectual property is needed and how these intellectual properties are governed. Now we will be dealing with all these intellectual properties individually, so that all your doubts relating See, every day you are using some sort of intellectual property, but you are not aware of what property. The pen in your hand also has some intellectual property. How? That I will explain you right now. When you are talking of copyrights, and first of all, copyrights and related rights. So what is copyright? Does that mean you have right to copy? No, you cannot copy anything without the permission of the producer. So copyright is a legal term describing rights given to the creators for their literary, artistic, musical, dramatic, cinematographic work, as well as sound recording. So first of all, understand what is the domain of copyright, what can be registered under the copyright. So basically, when you are talking of literary work, artistic work, musical work, dramatic work, cinematographic work, as well as sound recording. So see, whenever you come across these kind of 6 domains, you have to understand that it has to be necessarily registered under the Copyrights Act. You cannot get a patent or any other intellectual property right on these works except copyright. So the basic domain under which the copyright are granted are nothing but the literary, artistic, musical, dramatic, sound recording, and cinematographic work. So basically, it gives the creator of original work exclusive right. Exclusive right means only that person can use it. Nobody can use it without his permission, and it is also for a limited period of time. Now when we talk of copyright, now one thing comes to your mind. I have an idea. Suppose Dr. Prajakta has an idea and she says this idea to Dr. Dige, and Dige madam immediately writes something and expresses it in some form of the in some part of story or some part of literary work, and the and she gets a copyright protection. She goes for copyright protection and gets it. At that time, Dr. Prajakta says, "No, Arey, this was my idea. How madam has to taken that idea?" So mind you, copyright doesn't covers the idea and information themselves. Only the form or manner in which they are expressed is covered under the copyright. So the way how you are expressing, the way how you are presenting is the thing which will be getting the copyright and not any ideas. So mind you, when you come across idea, you don't tell all these ideas to somebody. You first execute that idea, put it on paper, get a copyright, and then you can disclose these things, because ideas cannot be protected, ideas cannot be covered, and the manner in which it is expressed. For example, you see many movies, the theme is of love story, right? Or the thing is of from a revenge. Now you see Maine Pyar Kiya, love story, or many other movies, Dilwale Dulhaniya Le Jayenge. The theme is of a love story, but the way it is in expressed is different, and therefore they are having a different copyrights. Now the theme is same, the idea is same, but the way it is expressed is different. So basically understand that you don't get any copyright protection on any ideas or information itself. Only the manner or form in which they are expressed will be governed with the copyright. Okay? Then coming to related rights. Related rights includes the rights of performers, then producer of sound recording, and broadcasting organization. Now, basically, when we talk of copyright, it is nothing but the creation of human work in the field of literary, musical, and dramatic art work. Now, what is that? We will see in this next slide. So basically the topic or the subject matter of copyright is literary works, films, dramatic, musical, artistic, sound recording. Now what is this? We will see. So suppose if you write a book or an article in a newspaper, or draft some question paper or a catalog, or write any dictionaries, even if you are read a lecture, if you are writing it in reduced to writing, or a computer software, computer program, lyrics of a song, etc. All these basically includes the literary work. So whenever we talk of literary work includes all these things. So whenever you are writing all these things, or whenever you are doing something related to this, it will be definitely has to be registered. It has to necessarily registered under the Copyright Act. So you don't go with that perception that I want to get a patent or all that thing. So whenever you are talking of literary works include books or any other things, and that has to be necessarily registered under the Copyright Act. Then when we talk of artistic work, artistic works may include drawings that may be in the form of maps, diagrams, plans, or charts. Then paintings, diagram, chart work, work of sculpture, engraving, then advertisement poster, industrial and engineering drawings. All these things which are related to artistic work definitely falls under the copyright domain. So whenever you are creating some artistic work, you have to get a copyright, right? Then musical work may exist in the form of graphical notation, sound recording, and as well as dramatic work may exist in the following, that may be in the form of play, recitation, choreographic work, dumb show in fixed in writing, then script, scenario of a cinematographic film. All these things cover under the musical and dramatic work. So we have also called as neighboring rights, that is broadcasters right. So broadcasters are the rights which a broadcasting organization is given for a broadcast. This broadcast could be a television broadcast or a radio broadcast. For example, you see Kapil Sharma show. You see this show only on Sony TV. Why not on Zee TV? Because the broadcasting or the channel has acquired the broadcasting rights from the producer of the show, and therefore they have the right, exclusive right to show that show only on Sony TV. This cannot be shown on Zee TV or any other show unless and until they acquire the rights. So basically, these are the broadcasters' right. You see, when India wins a match or some recommendable news comes with regard to any development in India, and that is shown on some news channel, we see the courtesy from so and so, courtesy from Doordarshan, courtesy from Star Sports. So that clips, even if they are shown on Star Sports, the news channels are acquiring the rights to show that clips by through the broadcasters right. So you cannot see, even Antakshari was seen on Zee TV. It cannot be seen on Sony TV. CID on Sony TV, not on other channel. So basically, understand there are broadcasters, right? And broadcaster rights are taken by the channels, and they have the right to exclusively show these things. Then performers' right also includes the rights of actors, singer, musician, dancer, acrobat, juggler, conjurer, snake charmer, one who performs a circus act, puppet show, a person delivering a lecture, or any other work of performance. So whenever it comes to performance, it has to be necessarily for registered under the copyright. Now, when you talk of section 1617 of Indian Copyright Act, it says that copyright registration is not mandatory. But it is always advisable that you get your work registered through copyright. Now, why? I will explain. There are many cases or there are many litigations which you hear about on daily, many times on TV, or many times you read in newspaper. So there was one case, Mahesh Vaijanath Doijode, who was challenged when the movie A Fan was releasing against Yashraj Films for injunction that this movie should not be released because it was his literary work in the name of Abhineta in 1997, and Yashraj Films has infringed his copyright on the same. But when the matter went to for interim hearing, the court denied, because court denied him any protection or denied him the interim injunction which he has sought, because he was not able to prove that how the Yashraj film got access to the plaintiff's work. Had in this case the copyright had been taken, he would have definitely got some royalty from Yashraj Films. So this was, or his name would have been included while releasing the story of the movie, that sort. So basically the idea is, once you get a copy, once you get that idea, and when you reduce it in any form of literary, artistic, musical, dramatic, sound recording, or cinematographic work, it's basically the theme that you get it registered, because the cost of getting a copyright is very meager. But once you get the protection, you have a lot of benefits. So basically, this is the thing related to copyright. So I suppose the domain of copyright is very clear to you. So whenever you come across literary, musical, dramatic, artistic work, cinematographic work, or sound recording, all this work necessarily falls under the domain of copyright and has to be registered under the Copyright Act. Okay. So I suppose copyright is clear with you. If you have any doubts, we will definitely address the doubts at the end of the session. Right? Now coming to another intellectual property, trademarks. Now what is trademarks? You see, अरे यार ये बंदा तो branded कपड़े use करता है या इसका सारा चीजें branded ही रहता है. So what is that brand? Brand is nothing but a trademark. So trademarks and also service marks are the distinctive symbols that help the consumer to distinguish between the competing goods or services and are a major part of goodwill of a company that company enjoys in a trade. Now, what is that? So basically, when you think of trademarks or service marks, trademarks are essentially applied on articles of trade, and because of which you identify that the product is belonging to that company or that product belongs to that company. And when we are talking of services, you can directly say that the products belongs, the services given by so and so company. What is that? We will see. Suppose, take a good example. Suppose you are going by a car with your family, and at some point your mother asks or somebody asks from you the car, I want some water. I want some mineral water. Immediately you stop the car at some shop and get down and go to the shopkeeper, go to the shop and ask the shopkeeper, यार what out of 190% people say, यार एक बिस्लेरी देना. Nobody asks एक bottle of mineral water देना. कोई ऐसा नहीं बोलता है. People usually say एक बिस्लेरी देना. So whenever mineral water comes to your mind, immediately one thing comes to your mind, that is bislary. And this bislary is nothing but the trademark of that company, and which is helping you that the product belongs to bislary and therefore it has particular qualities, a particular and that is the goodwill, that is the image of that company. So whenever similarly when you think of buying a paste, you don't go in for buying any other paste, but immediately one thing comes to your mind, a Colgate. आज में Colgate ही लेना है. Similarly, when we talk of salt, Tata Salt, shoes, Bata shoes, all these are nothing but the reputed brands or trademarks which are applied on the articles of trade, and which is identifying that the products are made by this company and therefore they have a goodwill. So that once that thing comes in your mind are nothing but the trademark. So trademark is a usually name of an enterprises which also individualizes the enterprise in the minds of the customer. So whenever you think of water, Bisleri comes to your mind. Whenever you think of toothpaste, Colgate comes to your mind, shoes, Bata. So these are nothing but the trademarks. So what are these trademarks? This is a sign capable of distinguishing the goods or services of one enterprises from that of others. So whenever you see this kind of symbol, immediately you identify that this symbol, that there is a McDonald's outlet, and therefore you may get some yummy burgers over there or some other things, finger chips or any other menu card from that McDonald's. Similarly, when you think of Domino's, you get whenever thinks of pizza, Domino's pizza, or that may be of Smoking Joe's or any other pizzas. Then when you are talking of, whenever you see this kind of symbol, the correct symbol that indicates that the that is a Nike symbol, and therefore a Nike shoe is there. Then Adidas, then Puma. So when you think of giving or sending something to other important note or important document or important thing, immediately you something comes to your mind that I should send this thing to Indian Post, or that may be through Blue Dart, or that may be through FedEx. So these are nothing but the service providers. So they are providing, these are the services mark. So whereas McDonald's, Adidas, all these things are the trademarks. Okay. Now, when you talk of subject matter, that may be in the form of brand name, just like that, and a tagline or slogan. Then certification mark, that may be in the form of BSI, Bureau of Indian Standard, ICs, FCCAI, or ISO 9000, all these are nothing but the certification mark. Now we also have sound mark. Where if you carefully see the advertisement of Britannia biscuits, a music comes, tan 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 tan. That's signal, that's sound. That is also a mark. Then of course logo, that may be in the form of combination of color, that is McDonald or any other. Now scent marks are also coming, but then moving marks are there. You can see this lion, roaring lion, that are also moving mark. So these are nothing but the trademarks. So now the concept is, whenever you see this kind of thing, that means there is a something trademark which is being used. So that trademarks includes word mark, device mark, that may be in the form of signs, symbols, logos, then collective marks, symbol, certification marks, service marks. All these are nothing but the trademarks. So basically understand that trademark is nothing but a sign capable of distinguishing the goods or services of one enterprise from those of other, right? Now you see how these trademarks have are to be created. It must, so first of all, it must be graphically represented. You should be able to represent it graphically. Then it must be distinctive, distinguishable. It must not be descriptive. You should not write a descriptive words, or you should not be deceptively similar to known or well-known marks. Now here, when you talk of a deceptively similar thing, that means suppose you are going in a market and buying a phone of Nokia, Now that Nokia has a spelling Nokia.
Haidas More, please mute yourself.
Okay. So whenever we are talking of Nokia NOKI, the spelling is, you go to that shop and you say, I want to buy a phone, and he says the price of that phone is suppose 7,000 rupees. Now you immediately go to some other shop and you buy that phone only for a price of 4,200 rupees. So you say that shopkeeper was cheating me, or definitely that earlier shopkeeper was charging me more money. But when you come home and you see the spelling is similar, NOKIA, where it is original, whereas NOKEA, that is a pirated, or that is a deceptively similar thing. So the mark is same, but then you realize, array, Nokia, the shopkeeper has cheated me. Then you go in for different kinds of arguments with the shopkeeper. Yeah, I had. Then you feel like that I have been cheated. So therefore, it should not be deceptively similar. So whenever you are buying something, you please ensure that you are comparing the things, you are getting the things proper. So the intention behind sharing this thing was that you should very well see, when you are buying some renowned brand products, there are chances that you may be getting some counterfeit product whereby it's a deceptively similar marks. So that should be not the case. That should not be the things for making a new trademark. So once, now you cannot use geographical indications, then deities, that is God's pictures or God's photos or God some national leaders, pictures, all these heroes, symbols, all these laudatory words should not be taken into consideration. There should not be the subject matter of trademark. You should necessarily create a mark that will have a lasting effect on all the things. So these are the well-known trademark. So whenever you have to once you want to buy that too, you go through Adidas, or you may go to Nike, or you may go to Puma. But then that is the image of that company. So when similarly, you just understand, once you think of water, you think of mineral water of Bisleri only. So this is nothing but the trademark. So basically understand that these are also the marks, and they are applied on articles content. Therefore, it is having a commercial value, and therefore it has to be necessarily registered. I told you the example of Nokia, what has happened in that case. So definitely the company will sue the other company once you realize that these kind of counterfeit products are available in market. So that part forms the litigation part, but these are nothing but the trademarks, and therefore they are governed and protected under the intellectual property. Now coming to, I suppose trademark is also clear with you. Then coming to geographical indications. So whenever you think of Agra, what comes to your mind? what two things come to your mind? One thing is Agra ka Taj Mahal, and second thing is Agra ka Peta. Similarly, when you are thinking of Nagpur, once you think of Nagpur or Nasik, then immediately one thing comes to your mind. What? Nagpur oranges are famous. Somebody says, your mother or some parent says, "Arey, Nagpur ja raha hai, to oranges leke aao." Or suppose you are going to Nasik, then somebody will say, "Arey, bring some grapes for me." So these are the geographical indicators. That may be in the form of basmati rice, Darjeeling tea, from silk, Alfonso mango, Kolhapuri chappal, Bikaneri bhujia, Agra peta, Goa feni, and finally coming when we are in Pune, finally coming to Puneri Pagadi also has got a geographical indication. Now what is that we will see. So geographical indication is a sign used on goods that have a specific geographical origin and possess qualities or a reputation that is solely due to the place of origin. Now when we are saying of geographical origin, now you see when you think of mangoes, you think of Ratnagiri mangoes or Devgad mangoes, or when you are thinking of oranges, you think of Nagpur oranges. Then if you are thinking of Paithani, Yola Paithani. So all these things are nothing but because the soil or the climatic features are such that the product goes in that specific area. So whenever in just now in next month in April or March, you will have many shops in Pune की देवगड आंबा मिळेल, रत्नागिरी आंबा मिळेल, हापूस आंबा मिळेल, fresh Alfonso mango from Konkan will be given. So all these things are the geographical indicators. Now what happens? Because once you have a choice of buying mangoes, see there are many types of varieties of mangoes available in market, but you prefer Alfonso mango because you know that the taste is so and so good, and you like the flavor, or they are so sweet, or they have their characteristic state which is you are acquainted with, and therefore you are preferring that. So you are even ready to buy that at more prices. So basically this right is not a right of an individual, it is a right of a collective group or a collective farmers or a collective persons from that area which are which are producing these kind of things. For example, when you talk of Kolhapuri chappals, then it comes to Kolhapur. So because they are a group of community or the group of the producers, they are producing these things, and they don't know that is the things which is famous. Then Solapuri chadar, Solapuri chadars are famous from Solapur. Similarly, when you are talking of mangoes and all other things, so the idea comes that, and once you export this thing by applying the geographical tag, you will definitely get a higher price. Or people in foreign countries also prefer Ratnagiri mangoes or Hapus mangoes or Nagpur oranges or Nasik grapes. So all these things are nothing but the geographical indicator indicating that the product belongs to that area, and such goods enjoy an advantage over the competing goods solely because of their geographical origin, and which thus becomes a intellectual property, and therefore it is registered and protected under the Geographical Indicators Act. Okay? So basically it indicates that the product is produced in a certain place and has certain characteristic which is due to the place of production. That may be Solapuri chadar or that may be from the Kolhapuri chappal. Then indication of source, it indicates that the product belongs to that thing. So appellation of origin does not only indicate the place of origin, but also the essential link between the product and area of its origin. Kolhapuri chappals from Kolhapur. So this is nothing but the collective right given to a community of farmers or community of producers from specific area.
Snail Zadar, please mute your mic. Snail Zadar, it's request to you, please mute your mic.
त्याच्यावरच सगळे स्कूल वगैरे भेटतात.
Hello. Okay.
गाडी आली का ग ताई?
Sir, can I reclaim the host because I have taken the host, so I cannot mute. Sorry for interrupting. Actually.
Okay.
तुम्ही इथं वाटलीच नाही.
कारण
यार ये कौन
The issue is sorted out, right?
Yes, sir. Yes, sir. You may continue, sir.
Okay. So this is the basically advantage of geographical indication. So coming to another intellectual property, that is industrial design. So what is industrial design? Now, industrial design is an ornamental or aesthetic aspect of an article. It may be in the form of three-dimensional features such as shape or surface, or of two-dimensional features such as patterns, lines, or color. Now you see every day you are coming across different designs of sarees or clothes or cars or furniture or any other things. So what are these? These are nothing but the industrial. Even you think of just eating biscuits. Biscuits are also, some are square, some are rectangular, some are having some dotted, some are heart shaped. All these are nothing but the industrial drives. So basically industrial designs are applied to variety of products that may be in the from handicraft, watches industry, jewelry, fashion, or other luxury items, industrial and medical equipments, then houseware, furniture, electrical appliances, vehicles, architecture, structures, textiles, designs, toys, etc. Everywhere in every field of production, you see different varieties. So this is nothingly basically the ornamental or aesthetic aspect of a article. Now, what is that? You see a Bisleri bottle, or you see a mineral water. So many shape or different shapes of bottles or what are coming that may be from 200 ml to almost 20 liters. You see every company is having different types of design. So these are nothing but the industrial designs. See, you see mobile phones, small designs, big designs, or different shapes. But you have a particular feature because of which that you, once you see that iPhone, you have a particular feature. Yes, I should buy that phone. But then that is the industrial design that is being applied. Now, when see, you had seen many chairs, traditional chairs, right? So when you have seen these traditional chairs, immediately at one point of time when you see this bump chair were introduced in this movie, and these chairs were so instant heat that almost all kindergartens or schools, nurseries, play schools, then play parks, all these small nurseries or all these things started installing or buying this thing. That was nothing but a ornamental or aesthetic look on the design was applied on the, that this is a simple sitting chair, but the way it is being designed, and it attract the lure, it lures the customer to buy this kind of things. So similarly, when you see water milk container, the different shapes of cycles, then different shapes of glasses, different shapes of bottles, and then you see you come across different shapes of watches, cycle, furniture. Now even you see in the present scenario of COVID, you see how different shapes of masks are coming. So these are nothing but the industrial designs, and they have a protection because they, once you get a registration or design protection, you get nobody can use that design without your permission. So similarly, you see jewelry set, cutlery set, furniture set, all these things are nothing but the designs. So industrial designs are nothing but the ornamental or aesthetic aspect of an article, and that appeals to the eye. Once you think, once you see that thing, you should you say, "Arey, wo cheez mujhe bahut pasand aayi." That the shape was so nice that I will buy that kind of car. I will buy a Volkswagen, or I will buy the Kia, or I will buy that kind of vehicle. मुझे उसका shape particularly बहुत पसंद आया. The design, it was design, the way it was designed, I like that thing. So that lures the customer to buy that thing, and this is nothing but the industrial. So again, these are applied on the articles of trade, and therefore they have a commercial value, and therefore they are covered under the uh, Industrial Designs Act. Now coming to another important intellectual property, that is maybe in the form of patents. When you are talking of patents, this is very important thing. So it's one of the important intellectual property. So basically, you see these kind of things on many articles, that maybe the patenting pending, or that may be a patented. So once you get a patent, that you many times the companies write that they have patented that product. Now you are recently seeing Shark Tank. I suppose many of you are seeing Shark Tanks. You say always the issue comes, I have a patented technology, or somebody is saying that I had applied and my patent is pending. So when you apply for a patent, that application is pending with that company, right? So basically understand that this is one of the important intellectual property. Now these slides will make all your differences very clear. Now when you talk of patents, it is an intellectual property right relating to invention. Now mind you, I am talking, please understand this slide. Once you understand this, once you okay. Patent is an intellectual property right relating to inventions. Now, once you understand this slide, all your doubts will be cleared about the patent. So this is very important slide. Please understand this slide very carefully. Now, I am talking of patent is an intellectual property right relating to invention. So when I am talking of invention, invention means necessarily it has to be an invention. Now there are two conceptions, that inventions and discoveries. So basically understand that there is a difference between inventions and discoveries. Many of these students, many of these scholars come to us by saying that I have made something. But when we find that is a very natural thing, or that is a discovered thing, so we say, we deny them the right. We cannot give you, patents are not granted for discoveries, patents are granted for invention. Simply understand that once Christopher Columbus was going to some part of the world and he found America. Similarly, when Vasco da Gama came on the Calicut beach, he found India. Similarly, there are many coal, minerals, research minerals. So basically, when we talk of these things, the minerals or these things, they are necessarily the result of the. They are necessarily the result of the what we say, that is the already existing thing. So it is not the thing that that was easy, that was readily available in the nature and somebody has found out. But when we talk of inventions, inventions are not anything which were already present in the universe. They are the result of human intervention. They are the result of several laboratory trials. You see, mobile phone, it was not lying in some part of nature and somebody has brought that invention to us. It was necessarily brought to our notice. It was similarly when it brought to our notice that invention was made through several trials, research, and R&D experiments, which were incorporated, and because of which the mobile phone was created, or many inventions were created. So basically, when we are talking of these inventions include the things which are the creations of the human intellectual and not of the discoveries. So discoveries are something which are already existence in nature, and which cannot be, somebody goes and find out. That means Newton's theory of gravity, that was a discovery. It was not an invention. But when Thomas Edison created bulb, that was an invention. So basically, patents are the intellectual property rights relating to invention. So it is an exclusive monopoly right. So understand that whenever you are having any intention of filing a patent, you keep in mind that you have to necessarily file a application for invention and not for a discovery. Therefore, it is an exclusive monopoly right. So exclusive monopoly right granted to the inventor by the government to use the patented inventions for a limited period of time, that is for 20 years, and thus preventing others from making, using, selling, or exchange, or in exchange of goods. So basically understand that it is an exclusive monopoly right. So in simple words, in Hindi or Marathi, we call patent as पेटेंट को हिंदी मराठी में क्या बोलते हैं? Somebody can tell me? Okay, I will tell you. So patents or in Hindi or English means ekaswa. Ekaswa means only one person's right. Ekka adhikar. Ekacha adhikar. So means that person who is created or who has invented that thing will be getting that right. So patent is nothing but a intellectual property right given to inventions and for a limited period of time by government. A limited period time, that is 20 years. Patents are granted for a period of 20 years. During these 20 years, nobody is allowed to use that invention or make an invention or import or sell that invention without the prior permission of the creator of that invention. So, but what happens? He has to disclose that thing to patent office. So once he files a patent application in our office, then once that patent term is over, once he get a patent, he will enjoy that patent for a period of 20 years. The more exclusive monopoly right will be enjoyed by him for a period of 20 years. But when that 20 years period is over, the invention goes to public domain. Then public is free to use it. Because whatever benefit that he wanted to get, he can scrutinize that or he can extract that benefits within the period of 20 years. But once that 20 year period is over, then public can freely use that invention. That is what the purpose of getting a patent is. So basically, patent is for an invention. It is an exclusive right to the inventor by government for a period of 20 years, thus preventing others from making, using, or exchanging in exchange of full disclosure of invention. I suppose this much is clear. Now, Dr. Dige comes to me and says, कि सर आपने पेटेंट के लिए तो बोला था इन्वेंशन चाहिए. I have brought an invention. Now give me a patent. Then at that time we will have to see where we will see there is a scrutiny test. That time we will say, ki madam, okay, now let me see what invention you have brought. So basically, while getting a patent, we look into these three important aspects. That is novelty, inventive step, and third part is industrial application. Now, what is that new novelty? Novelty. So when now you are having an invention, then we will see what is novelty. Novelty means newness. It should not be a copied material. It should not be a replica of some other person's work. You should not copy it from some other journal or some other thing. You should not carry out that thing. So we have a very dedicated team of examiners specialized in this field of technology, wherein we also have a databases, wherein we get all the paid databases, wherein we get all the data related to patent or inventions or related to all these fields. So once that dedicated examiner certifies or searches, he brings out n number of documents. Sir, these are the documents which is destroying the novelty, therefore this invention is not new. Then we have to certain. So basically understand that there should be novelty, that not only the invention but the invention should be new. You should not be known to somebody. You should not be copied work of some other person. After crossing the hurdle of novelty, then comes the inventive step. What is that inventive step? Inventive step is that feature of an invention that has, mind you understand this, that has technical advancement over the existing knowledge, or there is economic significance, or both, or any one of them is sufficient to prove that there is an inventive step. Now, what is that? What is technical advancement over the existing knowledge? See, earlier during the during 90s to 2000, we were using a floppy disk in your computer. That was having a very small 25 MB or 250 MB. So eventually there was a development in that field. Then came with a 250 GB pen drive. Then came with a 1 GB, now 32 GB, now till 1 TB pen drives are there. Eventually there is a technical development, technical advancement. Similarly, where you were in earlier days, our grandfathers or forefathers were using the gramophone or recorder. So you were listening the sound or music on that gramophone. Then eventually came the development of cassette players. Then cassette players were developed. Our fathers were using that cassette players. Now in the present scenario, then the CDs came, then VCDs came. Now all these things are nothing but the technological advancement. So technical advancement in this field has extensively taken place. Earlier, we were using black and white TVs. All the developments that happened in the telecom industry, or that the development that happened in the any other electronic industry, or in the electronics products, or in any other field, that is nothing but the technical advancement. So first of all, there should be a technical advancement over the existing knowledge. Whatever knowledge was there, what technical advancement has been added there is been taken into consideration. Or economic significance. For example, earlier in a drug was costing rupees 10,000 rupees, and now you have prepared the same drug with a cost of 5,000 rupees or 2,000 rupees. So yes, there is a difference, or there is a difference in the costing that definitely will have a economic significance. So only one aspect is required, but when you have both the aspects, it's well and good. Then we clarify the, or when we clear the inventive step. So once we see there is a technical advancement or economic significance, we proceed further with that invention. Now the third part comes of industrial applicability. What is that industrial applicability? Means you should be able to produce that article in n number of quantities. N number of quantities means you should not, suppose I have taken a patent on a car and I will only use that car for myself, then the reasonable requirement of public will not be satisfied. Public will not be getting that invention. So basically, you have to see, you should not block the technology, but you should reasonably satisfy the requirement of public at large for getting the car to available to everybody. You should make that car available to everybody. Now, just coming to one good example here, in the recent times, just in last 3 years, you had seen when the COVID started, Remdesivir injection was costing some 80,000 or maybe 40, 50,000, whatever n number of prices were being quoted, because there was, the company was only having one, Gilead in USA was having the patent on that molecule, Remdesivir. But during that period, the cost, because they were not able to satisfy the requirement of public at large. So Section 84 of the Indian Patent Act has a provision wherein a compulsory license can be granted by government in case of when the reasonable requirement of public is not satisfied, or the company is not able to make the invention available to the public at a reasonable price. So where almost eight cross licenses were given by Gilead to other companies, and because of which that Remdesivir came, the price of Remdesivir came to 4,000 rupees or less than that also. So because of these eight cross licenses, the reasonable requirement of public was satisfied. So that is nothing but the industrial applicability. Now, I told you the invention must be new, then there should be technical advancement or economic significance, and the third part is you should be able to produce that article in n numbers and not restrict it to yourself, or you should not block the technology, you should make it available to the public. Apart from this, there are certain exceptions under section 3 and 4 under which patents cannot be granted. For example, if somebody is asking me a method for treatment of some disease, we will say no. Then a method of agriculture, no, we will not give, because India is a agriculture country, and once the technology or the method for doing agriculture is patented, imagine the thing, what will happen to that? What will happen to that? Amol, bol. Just a minute, sorry. बोल.
सर कनेक्ट करायचं आहे का म्हटलं मला?
जाऊ दे, आता मी करून घेतो सर. सो ठीक आहे.
करून घेता ना? ठीक आहे.
Okay. So basically these are the things. Then somebody is asking for method of treatment. Then again somebody is asking for some frivolous invention. Somebody has made an invention which is used for housebreaking, or which is dangerous to industry, which is dangerous to mankind. Or somebody is making a bomb, then we cannot give them that patent on that technology, because that is against the moral principles and against morality, so we will not give. Similarly, section 4, when we talk of, that means inventions related to atomic energy, which can be a threat to Indian security or our country, that kind of inventions we are not giving it. unless and until we get a clearance from Department of Atomic Energy. So basically understand that patent is related with intellectual property is related with inventions. That invention has to be new, inventive step has to be there and industrial applicable. And also apart from that, it should you should not claim any method of treatment, or it should not claim any method of agriculture, or it should not be against morality or against or principles. And also it should not be against any defense, or it should not be threat to our defense or other thing. So this is what the idea of patent is. Now the patents is a very old form of intellectual protection, property protection. What is that? Because in earlier times, even in the kings, during the period of kings or emperors which were ruling the country, we had a different sort of protections that was given to this thing. For example, a king or an emperor was having cooks at that time to cook some dishes, and the cook, if he produce or if he create or if he prepares some dish, and the king, if that dish was liked by the king, then the king used to give him not only monetary reward, but also whenever he wanted to eat that dish, he used to ask that cook only to prepare that dish. So this, just the existence of patent system can be traced from that century. So earlier also the cook who used to do that thing, or some work of technology, or once a work of some skill was done by some person, that person would have would get a benefit of that technology, or benefit of that whatever artistic work or architectural work he used to get. So he used to get reward for that thing. So understand that it is not a new nothing, but it's a history which is going on from 17th century. Now, why I am saying is, the aim was of the patent system is to encourage the economic and technological development by rewarding the intellectual creativity, right? So basically the theme is, you should encourage the economic as well as technological development, and therefore you are rewarding the individual intellectual creativity. Now once the see, we come across many inventors who are not producing only one or two, they are coming with n number of inventions, they are filing n number of cases. We come across many things, many people who are filing applications for patent, they do different ideas. Even you see now the Shark Tank, there are people saying, I have five patents, or I am a technology man, I am a patent man, I am getting patents on so and so. So this is nothing but the encouragement. And once that technology, if he gets somebody clicks that technology, he will definitely get the benefit of that thing. So see, again, I told you it's a very old thing. So in 1856 also, a civil engineer, before the revolt of Indian freedom in 1856, before that Indian 57, there was a patent system in force. George Alfred Depenning, who brought from Grants Lane, Calcutta, got a patent from his efficient pulling machine. So this is the efficient pulling machine wherein he has got the patent on that, right? Now, here I would like, but since Amol is busy with some other, Amol Patil was the person who who wanted to go ahead with this session again, but now I have received a call from him, so he's busy with some other activity. So I will continue with the session. Okay. So now,
Okay, sir.
so Mr. Amol Patil is busy with some other activity. No, he just called me up.
Yes, sir. Fine, fine. You can continue.
So I will continue with the session. So it's not an issue. Then comes to another intellectual property, that is semiconductor integrated circuits, layouts, design. These are basically the layouts of a circuit, integrated circuits. Is a relatively new area of intellectual property which has appeared in the computer technology and has acquired importance as the technologically rapidly advances. Now, what is that? See, when you are talking of patents, topography of integrated circuits are barred. They are not given patents under Section 3 of the Patent Act. Therefore, to give protections to this, Whenever you see these kind of motherboards, or whenever you see these kind of things, these are electronic circuits, and this function to create something. Because see, you are using a mobile phone, you are having this kind of motherboards or circuits on which, because of which you get the whatever necessarily the result you get. Whenever you see television, you, or whenever you use computers, you get these kind of things. So basically these things are the integrated circuit. Just keep in mind that this is also an intellectual property. So whenever you come across these semiconductor integrated circuits, these are also getting protection under the Semiconductor Integrated Layouts Act. So this is for your knowledge. This is a very advanced stage in the IC chips and all that things related to motherboards or semiconductor integrated circuits. Basically, semiconductor circuit means a product having transistors and other circuitry elements which are inseparably formed on a semiconductor material or on an insulating material or inside the semiconductor, and designed to perform a electronic circuitry function. What is that electronic circuitry function? That means a computer works, because of which now the technology you are using, Google, Zoom, all these things are giving some results. So that is nothing but a technology. So because of these, you just see that circuits, whenever these circuits comes to you, you see that there is a protection under the Semiconductor Integrated Circuits Act. So whenever you see these kind of motherboards, whenever that may be in the mobile phone or maybe television or some other sector, you, so that is in electronic item, that is nothing but the semiconductor integrated. Now coming to another aspect of intellectual property, that is a trade secret. Trade secret, what is that trade secret? Trade secret is any practice or process of a company that is generally not known outside the company, and information is considered as a trade secret, because of which the company has an economic advantage. And basically the idea is a agreement of confidentiality. Now see, what is that trade secret? Here, there is no mode of protection. The mode of protection is the company keeps whatever the things they are producing, they keeps that recipe or that thing as a trade secret. They are not disclosing the recipe or the things how they are made. They are not getting any patent. They are not protecting any claiming any protection on that. For example, now you are using Google. Whenever you come across some sort of thing, for example, you want to search modern college Pune, so you just put that thing word in Google search, Google, and you get n number of documents. Now how that n number of documents are produced, nobody knows. The search algorithm made by Google, they have kept it as a trade secret. How you are getting that data, nobody knows, but the algorithm is protected in its place. Nobody is knowing how that works, but you are getting the data. Similarly, anything, if you want to search, just put the keywords and you get the data. That is the secret. They have kept that as a trade secret. So Google's search engine is one of the the algorithm. What the algorithm is, nobody is known, but they have kept it as state secret, and because of it, it's still having a good position in market. Google search is the most preferred search till now, because you get some very authentic documents or very authentic data from that search. Similarly, you see KFC fried chicken, that recipe, how that fried chicken is made, nobody knows. The recipe is kept secret. So the people who are working there also are not aware. And some the partners who are aware of, they are bound under the agreement of confidentiality, and they cannot disclose that thing. Similarly, McDonald's mustard sauce, that is Big Mac's special sauce, is also protected. And one of the good example of Coca-Cola. Coca-Cola is also, the formula of making Coca-Cola is also a trade secret. Now, then WD-40, that is anti-rusting oil. Again, what content is there, nobody is aware of, but then they have kept it as a trade secret. Now, when we are talking of trade secret, one important case law we can see of that of Coca-Cola. Now, what happened? See, Coca-Cola has kept its formula as a trade secret. But in earlier phase, in 1893, Coca-Cola got a patent right? The patent was taken by company Coca-Cola, the company Coca-Cola, and that patent lapsed after a period of during that time the period patent was for 14 years. So that formula, once that 14-year period was over, Coca-Cola was freely available in market. Everybody was producing. I told you, once the patent right is over, public can freely use that invention, and this has happened with Coca-Cola also. So Coca-Cola was easily made by some other people. So to make that duplication or to avoid that thing, they made some changes in the formula. They have changed the taste of Coca-Cola by making some other minor or some alterations in the formula which they had patented. And after that, they had produced another Coca-Cola. The taste of that Coca-Cola, right from 100 years till date, is the same. And it is being kept as a trade secret. Nobody knows. There are so many bottling plants, but they don't know. They just mix the tablets and may prepare that Coca-Cola, but nobody is aware of what is the content or how that, what is the ratio or proportion of that contents of ingredients of making that Coca-Cola is not known. They have kept it as trade secrets. Even there are many stories on internet wherein you can see, we hear that the partners of Coca-Cola never go in same plane, or they never come across the they never travel in the same car, or they never travel in the same flight. These are the things which are keeping them the way they are keeping the secrecy is the good example of Coca-Cola. So the taste of Coca-Cola is still date kept as a trade secret. So this is nothing but the very good example of trade secret. Mind you, you can keep your knowledge to the, or you can keep your recipe or thing as a trade secret also. This is also one of the intellectual property, but the form of protection is by only the confidentiality agreement that they make, the internal partners make with the company. Then you come across different shapes of plant varieties. Now, earlier you were using green capsicums, then red capsicums. Nowadays you are coming across yellow capsicums, orange capsicums, different shapes, colors of capsicum. Even the colors of flowers have changed. You come across many different colors of flowers. If you go for some flower exhibition, you see different varieties of different varieties of roses are there available in the market. Similarly, BT Bengal, that is brinjal, all other different shapes of uh, fruits or different sizes of fruits are increased. Or now you see the custard apple, different sort of custard apple is available in market, or different sort of oranges are available. So these are nothing but the development in that field, that may be from tissue culture, or that may be the effort of the farmer. So basically, to protect the farmers and plant varieties, the Protection of Plant Varieties and Farmers Act was in place, and this is the act which protects the right of farmer and plant breeders, and therefore encourage the development and cultivations of new plant varieties. So this is again one of the last important intellectual property. Now I told you every strong country or every developed country needs a strong intellectual property regime or intellectual property rights for its technological as well as social or economic development. So we also in India also, how I told you earlier also, we have a very strong intellectual property protections available under the different act. For example, when you talk of patents, the patents are governed by the Patents Act 1970. Its registration is compulsory, that is for a period of 20 years. Similarly, trademarks are governed by the Trademarks Act 1999, and the registration is optional, though it is not necessary, but it is always advisable. I told you it is always advisable, and it is for a period of 10 years, and it is renewable forever. Then coming to designs. Designs are again governed by Designs Act. Its protection is for a period of 10 years, and you can renew it by another 5 years. Geographical indications, they are governed by the Geographical Indications of Goods Registration and Protection Act 1999. Its registration is compulsorily, and it's for a period of 10 years, and it's again renewable forever. Now, coming to copyright, there are various amendments. So I will talk the Copyright Act 1957 as and when amended. The copyright, the period depends on different categories, but optionally it is for a period of it's period of lifetime of author till the livingness of the author plus 60 years from his date. So that is the end of the copyright. But broadcasters right and all that things have different periods that can be seen in the Copyright Act. Now coming to plant protection, we have a protection of plant varieties and farmers right act that is governed under 2001. Its registration is compulsory. It's for 15 and it's for trees. It's basically for 18 years. Then integrated circuits. I told you that the Semiconductor Integrated Circuits Layout Design Act is there. The registration is compulsory and it is for a period of 10 years. Now, in simple words, I told you, once you have idea, the way you are expressing it will be giving you a copyright. That may be in the field of literary, artistic, musical, or dramatic work. And once you have an idea that may be related with some innovation or invention, that will definitely lead to patent. Similarly, when you have idea and you have talking of quality or identity, then that will necessarily lead to a trademark. Also, if you have idea and appearance, the shapes, that will definitely lead to a design. So basically the theme is whatever idea you are having and the way you are expressing it, that may be in the form of literary artistic work will give you copyright. Whenever you are using an idea for some technology development, that may be in the form of patent inventions. Then idea with regard to identity, quality, that will be trademark. And then when idea with regard to appearance will give you designs. So this is what I have to say from my side. Now coming to, I suppose everybody has understood it. So before going in for any other questions, we will have a small quiz and I want to know. So how, what kind of things or how much you have gained from this seminar. So I will show you. So madam, please unmute the participant so that they can participate in the quiz. Now we are showing you some 5 pictures. Can anybody tell me what sort of protections can be given to claim picture 1? Can anybody tell me what is this property related with?
Copyrights.
Copyrights.
Yes, it's an artistic work made by an artist, and therefore it's a Mona Lisa movie, Mona Lisa picture, and that is being covered under the copyright. The second work, can anybody tell me what? It is the work of sculptor. Again, it will be form again part of
Copyright only, sir. I think.
copyright. Now here comes the third misleading picture. What is
Trademark.
that misleading picture?
Design.
Trademark.
Trademark is there. Again, something can be seen.
Design.
Design also is there. Very good. Again, what can be seen?
Patent can also be done, sir.
Yes. Very good. Then figure 4 is talking of distillery. What is
Trademark.
that?
Trademark.
So I suppose that is clear with you. Fifth is a bottle of Coca-Cola. What is that?
Trade secret.
Coca-Cola is a trade secret, that is thing. But what you are seeing here is the shape of bottle. Bottle is there. So that will lead to design.
Design, sir.
Now I will ask you some questions. Now, which type of intellectual property protects paintings painted by artists?
Copyright.
Copyright.
Very good. What protects the intellectual property created by fashion designer?
Registered
Designs. Very good. Now, what protects the advanced disc brake for bike developed by an inventor? Patent. The question itself answers the inventors means invention, and therefore disc brake is technology. So then which of these is a geographical indication?
Paitani sari.
Very good. What does a trademark protect?
Any mark.
Logos,
Idea,
names,
quality, and
Logo and names and brands.
Very good.
names and brands.
How long do patents usually last for?
20
20
years.
years.
20 years.
Very good. If you write an original story, what type of intellectual
Copyright.
property? Copy.
Copyright.
Oh my God, you are all aware of all these things. Imagine a cricketer sets up his own company to sell his own range of clothes. What type of
Set trade.
It's paid
Trademark. And he can
Trademark.
also
The
use
design trademarks.
registered
Trademark?
designs.
Correct. Trademark. If a company develops a new technology,
Patent.
patent.
patent. Okay. Now this is my official. We have an official website, that is www.ipindia.nic.in, wherein you can get all the information related to these intellectual properties easily available on the website. Plus, you can have my email address. You can call me whenever you have any doubt. Now, this is what I have to say from my side. But looking from the quiz part, I suppose all the candidates are very much acquainted, or they are aware of what kind of intellectual property. Now, can anybody please stop that? Okay. Now everybody is having a pen in their hand, right? All right. All right. Now, how many intellectual property rights are there in the pen? Can anybody tell?
Sir, a trademark
Design.
can be done.
Patent.
Patent. Trademark.
Patent, trademark,
Trademark, design.
design. See, every company has its different design shape pens, right? So design is already there. Now every company has a logo or something, that may be Renault, Rorito, Mont Blanc, or that may be Parker. It's a trademark, right? Then they have some technology. You are reading that V2 Tech Point, Swiss German ink, flow technology, German ink, all that tip, Swiss tip.
Patent.
All this is nothing but the patented part. Now the manual, instruction manual, that how to use that pen, that also will have a copyright. For example, if you are using a pilot height point, you get a slip on that. How to fill the ink, what kind of things are there, how that ink has to be added, and all that thing. That is the material of copyright, right? So basically, the aim of telling all this thing is that you are using intellectual property every day in every aspect of your life, right from your bathroom, right from to your bed, or right from all your vehicles, all the things are covered under the intellectual. So see, now in simple way, you see, every day you are using something, but you are not aware of that you are using some intellectual property with it. If you are just pressing the button of fan, you are enjoying fan cool air. Then if you are using a air conditioners, you are using that thing. But then you are using every day, you are saying, I'm using Tata ka Bata ka shoes, then I'm using Nike, I will go to McDonald's, I will go to what is there in Pune, that which parathas are famous, that
Chaitanya's paratha.
no. Just opposite to that, next to that Amrapali Vaishali line.
Bahubali.
No. Next to that, near that Deccan corner, near that Archie's.
Paratha house.
Paratha house, Bahubali paratha.
नहीं मैडम, एक बहुत अच्छा नाम है वो. Anyway, we are very much
Vadeshwar,
right? Vadeshwar. That is the different brand. So whenever we come to Pune, we meet at Vadeshwar. So these are nothing but the intellectual properties which you are using daily in your life, but you are not aware of. You might be aware of, but you were not aware of. But from today, I suppose you will every day, in every part of aspect of things which you are using, you will say that इसमें design हो सकता है, इसमें trademark हो सकता है ना? Did you get my point?
Yes, sir. Yes, sir.
Yes, sir.
Now the session is open for question answers.
how to register trademark step by step in with Indian
How?
government.
See, every intellectual property has a procedure under which certain forms, just like other properties you are buying. If you are buying a house, you are going to registrar's office and completing the formality by filling the forms and all the things. Similarly, when you want to file a trademark, see, trademark is another thing. The registration is not compulsory, but it is always advisable. I told you earlier also that it is always advisable that you can use. You can surely you can just protect it for the sake of safety. Now there are people who are using these trademarks for 100 years. Earlier also Chitale was using that thing, then they came and then they registered and all that thing. But the particular area has some sort of thing. So basically there are certain forms and certain requirement that is available on our website. You can just fill in the forms which are required for claiming that patent. And we have a dedicated team of trademark examiners who will conduct a search on that. And whether they will ascertain that somebody is using that thing, or that mark is a deceptively similar mark, or somebody has already got a trademark on that thing. And the procedure is that once the examination report is sent to the applicant, whoever has filed the application, he can reply that to that examiner or to registrar. And after that, if the examiner is satisfied, he will write his report. And if there is no objection or there is no opposition, then the trademark can be granted. So basically a simple procedure you have to follow. You can get it online also, or on the website also, how to file a trademark. That procedure is also there. Certain forms are there that needs to be filed up, and certain amount of fees, just like you are going to RT office for getting a license, or you are going to a registrar office for getting your car, your home registered. A similar procedure has to be done. Only here the period takes longer, because we have to ascertain whether similar mark has already been protected or given protection to other user. And in case some opposition comes, then we will have to wait for some time. So that is what the procedure is. And everything is available on ipindia.nic.in. So you can go in for there also, and you will surely get the advice or the information that is required for filing. But simple procedure is there that has to be followed. Okay. Any other question?
Okay, sir. Thank you.
Okay.
Participants, are we all done with question answers round?
If you have any queries, you can please ask me right
Yes,
now.
yes, yes.
Or if you want, I have given my email address. Dr. Dige madam will coordinate me if any doubts are there. You can
Sure.
always ask me on email also.
Yes, sir.
Is there anything to be asked or any doubts?
Yes, if anyone has any doubt, you are free to ask.
First of all, let me know how was it useful, or anything you have been added to your earlier knowledge by this.
Sure, sir.
Yes, sir. Yes, sir.
Definitely it
Yes,
has.
sir.
Yes,
Yes,
sir.
sir.
Okay.
Yes, sir, absolutely.
So today by going home, you will definitely say to your kids or to some of your friends or colleagues that these are the things which can be protected, or these can be things. So you can just replicate this knowledge to them also, so that they can understand. And see, mind you, this is a very developing part wherein you can create miracles. I will tell you an example of Arun Jaitley. There was a person who has registered his name under the Dr. Arun Jaitley, arunjaitley.com. And when Arun Jaitley sir became minister, he wanted to claim you start using that domain. So, but when he searched, it was found that somebody has already taken that registration. So, mind you, he got around 2-3 crores as a royalty for getting that transfer to Arun Jaitley sir. So, this was the thing that there are many things which can be created by the revenue of just you are using the Coca-Cola bottle or the Pepsi tin which you are using, that may be of Haldiram, or that tin opener has created miracles. The person who has produced this is earning almost 4 to 6 crores every day for a period of 20 years. Because of just that technology, he has invented that open lock system of that tin, that may be of Pepsi. That he has given so many licenses to all the companies, that may be Haldiram or any other. Even Chitale is using. Everybody is using that technology. So they are collecting huge royalties. So even the Tachni, you say that T-pin, just small pin, has created wonders. See, everybody, in every part of office, that T-pin was used, and now though it is, the period is over, but it is publicly free to public is free to use it. So see, these are the bad advantages of the intellectual properties. So I suppose you all are done with the questions, or you don't have any questions, or I suppose that your all doubts are cleared. So I am very much thankful for giving me this opportunity.
Sorry to interrupt, sir. There is one student. She has raised her hand.
Okay.
Ask questions.
Uh-huh.
Will we take
Please.
her, sir?
Yeah, please.
Yes. Vedashri, please ask your question. Vedashri, are you there?
Am I audible?
Yes, you are.
Yes. Sir, I wanted to ask that there might be something which can be protected under patent also, or under trade secret also. So like,
See, madam,
can we get protection under both the
no. See,
and
in
then
trade
how?
secrets, in trade secret, this is for your knowledge. In trade secret, nothing has to be done. You do need not have. You just keep that formula restricted to you by a confidentiality agreement, and that is for your internal purpose. You need not go and register that thing. So no registration takes place. It's the contract between the person who are entering the organization, or using uh, the trade secrets. Whereas in patents, you have to disclose everything to office, patent office.
Okay. And sir, if it has got registrability under two acts, then how is it
No,
determined?
no, that totally depends on. I told you, Coca-Cola, they had earlier patented that thing, right? And then after because patent rights is limited to certain period, so 20 years. So
Yes.
after that, your invention will go to public.
Yes.
Public can freely use it. So that depends on you whether you want to. That depends on you whether you want to use or not. So what protection you want to protect, that totally depends on you. But major people are protecting it for getting it through patented, because they can sell that technology, right?
Okay.
So if they don't want to continue with that, they can find a, because there are many students, there are many inventors. You might see that in Shark Tank, these people are asking for some budget. Sir, हमको इतना चाहिए for stake of 2% equity or 1% equity. All these things are nothing, because they have the technology, but they don't know how to market it, or to master it, or to how to go ahead with that technology. So that depends. So people are preferring to get a patent, sell the technology in that field of area, and get money, encash that money.
Okay. Thank you, sir.
Okay.
Thank you so much, sir. It was indeed an enlightening, and I must say was very interesting. The quiz was cherry on the top, sir.
Yeah. And I suppose all have addressed it very properly.
Yes. Yes. So I thank you from my bottom of my heart, sir. I would like to thank our respected chairman, Dr. Professor Gajanan Egbote, sir. Respected coordinator of Modern Law College, Dr. Advocate Chintamani Ghate, sir. Respected principal, ma'am, Dr. Sunita Adao, ma'am. Respected vice principal of Modern Law College, Dr. Ananya Bibbe, ma'am. Last but not the least, all the teachers, students of Modern Law College, and all the participants for joining today and making this workshop a grand success. Thank you so much, sir. It
Oh,
was
thank you.
indeed a pleasure to have you here today, sir.
Madam, when I belong to Pune only, I stay in Aund only.
Oh, that's great, sir.
And we studied in university and I have a very good rapport with modern college. My guide was Dr. Dole, who was from modern law college. But Dr. Bharti Dole, she was there in Shivaji Nagar. And we used to play on the ground where now your college is. We were in 92 to 94 in university. So we had good memories. I had many friends in modern law college. From that commerce college, of course, then geography department.
Great, sir. Great, sir.
Now this law college has emerged since last 5-10 years. I don't know how many.
So, sir, then we can look forward to have you here physically someday.
Yes, madam. I always visit to my place, so I do.
Okay, sir.
Okay.
Thank you. Thank you.
Nice meeting you. Thank you for your patience hearing. If you have any doubt, you please feel free to ask me at any time. Right?
Sure, sir. Sure, sir. Thank you so much.
Thank you. So I will take your leave.
Yes.
Thank you so much.
There is a request to all the participants. We'll be providing a feedback form.
Okay, ma'am.
We'll be sharing a feedback form soon on the Telegram group. Kindly fill that feedback form so that your e-certificates will be generated based upon that feedback form. I hope this is clear to all.
Yes, ma'am. Thank you.
Yeah, thank you for being here. Thank you so much.